Salut les Mauriciens légaux, bienvenue à notre chaîne The Legal Mauritian. Nous faisons des vidéos pour partager notre connaissance et d'augmenter la vôtre sur la loi mauricienne d'une façon informative et divertissante. Le format de nos vidéos seront en différentes langues, alors excusez-nous si nous faisons des transitions brusques. L'important, c'est qu'à la fin de apprendre un nouveau quelque chose. Today, we'll briefly talk about the sources of law in Mauritius. Continuons la sortie. Our law was French in the beginning, and with the coming of English law, it has blended into an authentic Mauritian law. In effect, it has evolved to produce a distinct juridical personality. In general, our laws are made by three main bodies: the legislature, the judiciary, and to some extent, customs. So without further ado, let's dive straight in the first source of law, legislature. There are three types of legislations. We have the supreme legislation, also known as the Constitution. We have primary legislation, and finally, we have secondary legislation. The first one, supreme legislation. The Constitution is a document which attempts to regroup all the legal provisions which will govern the relationship among the various organs of the state. Ça veut dire Parlement, gouvernement, et la Cour. It also lays down fundamental rights of Mauritian citizens, such as Article 4, the right to life, Article 12, freedom of expression, and Article 16, protection from discrimination, and so on. En tout, notre Constitution consiste de plus de 122 articles. Et sous l'article 2, the Constitution is the supreme law of Mauritius, and if any other law is inconsistent with this Constitution, that the other law shall, to the extent of the inconsistency, be void. C'est-à-dire, si une loi est contre la Constitution, en d'autres mots, inconstitutionnelle, cette loi sera non valide. D'ailleurs, comme un fun fact, c'est l'article 1 de la Constitution qui octroie l'identité légale de l'île Maurice. Mauritius shall be a sovereign democratic state which shall be known as the Republic of Mauritius. Un peu comme un code d'identité. If you want to have a look at our constitution, there is a link in the description below. Now, moving on to the second type of legislation, primary legislation. Like in other modern democracies, primary legislation is the most important source of law in Mauritius. Under section 45(1) of the constitution, legislations are created or changed in parliament, that is, the National Assembly and the President. The National Assembly will be presented with a bill of parliament, and after debates, there is a vote as to whether the bill is passed or not. Then, the bill is sent to the State House for the assent of the President, the head of state. All bills or laws passed by Parliament are called Acts of Parliament. So where can you find Acts of Parliament and other legislations? There are several ways to find legislations. If you know the name of the legislation, you can simply search it on the internet, and you should be able to access a PDF copy as you can see here. Or, if you know the name of the main act and looking for related legislations, you can use the Supreme Court website. You will need to register and then log in to be able to access the information. Once you're logged in, you can click on the legislation tab, change exact keyword to any of the keywords, and take the years away. Search for your act, and there you go, you can see dozens of documents related to the main act. Now, if you're not familiar with any legislation, you can start by looking into the websites of different branches of the government. Judging from the problem you're facing, sometimes you can have an idea which ministry may be involved. For example, if you're facing a problem relating to your workplace, you can go to the Ministry of Labour's website and go on the legislation tab, and there you will find the main legislations related to employment. Now let's move to the third type of legislation, secondary legislation. Apart from Parliament, a number of legislations known as enabling acts or parent acts allow subsidiary organizations to pass secondary legislations. They are used to amend, update, or enforce existing primary legislation. For example, the Local Government Act enables municipalities and district councils to pass regulations about their respective municipal markets. Government authorities are also given powers through enabling acts. Let's take the Financial Services Commission, for example. Its website shows all legislations which give them their role, functions, and powers. For example, we can go on the Financial Services Act 2007 and read about their main functions and powers. One important thing to note is that secondary legislation is as much part of the law as an act of parliament. The courts can question whether a body, when issuing a secondary legislation, has acted within the powers given to it by the parent act, but the court cannot question its validity for any other reason. So, this was a brief explanation on Mauritian legislations and where you can find them. Now let's move on to the second source of law, case law. Case law is judge-made law which interprets statutes, c'est-à-dire la loi parlementaire, constitutional provisions, regulations, and other case law. Legislators cannot spell out every possible circumstance in statute. Hence why courts are important to interpret and apply the law. It is a major source of law, and in many cases it creates binding precedents. This means that subsequent cases must follow this law, and this principle is called stare decisis. Case law is created by judges in their rulings in court, when they write their decisions and give the reasoning behind them. In legal terms, this is called the rationale of the case. Judges also cite precedents on other cases that had a bearing on their decisions. Case law is also referred to as common law. The UK, Australia, Canada, and New Zealand all follow the same system. However, it must be stressed that Mauritius is not a purely common law country. The system has combined elements of the common law and civil law. Our civil law is derived from the French Code Napoleon, and then coined as the Code Civil Mauritian. So, this was a brief illustration of how courts create legal principles through case law. Now we move on to the third and final source of law, customs. The earliest system of law in human society were customary. Custom is a guide for courts in circumstances where nothing is prescribed by law. It is recognized as a general source of law in Mauritius, and it can be described as the established patterns of behavior that can be objectively verified with a particular social setting. Unfortunately, we were not able to find any examples of customary law in Mauritius. So if you know any, please comment in the section below, as we will love to learn from our viewers as well. Hence, this was the sources of law of Mauritius in a nutshell. Remember, laws are created or changed in Parliament and interpreted and applied in the courts. And sometimes we refer to customs when there are no previous provisions. If you like this video and want to learn more about Mauritian law, please subscribe to our channel. We are the Legal Mauritian.